Hello, everyone. Can everybody hear me? Well, good, you should. My name is Lawrence Davidow, and I'm with the law firm of Davidow, Siegel, and Stern. Has anyone ever heard of my law firm before?
Oh, yes.
Oh, well, you better have. Because my law firm was started actually in Patchogue in the year 1913. Wow. How do I look? Thank you. By my grandfather, followed then by my uncle, and then my father, and then guess who? Well, nobody was surprised to find out when I got out of law school that I got a job. But everyone was surprised to find out that I changed our family practice into the very first elder law firm in Suffolk County, and that's something I'm very proud of. Wow. Yay! I'm also proud that I'm a past president of the National Academy of Elder Law Attorneys. I'm known throughout the country for elder law, but I'm just a hometown guy. I went to Bellport High School a few years ago. But I'm in a good mood today. Is everybody in a good mood?
Yes.
Yes. Are you ready to talk about death and dying?
Sure.
Yay. All right. Well, I'm going to be talking about elder law today, and I hope that what I have to say about elder law that you'll find it interesting, and I hope you'll take that information home to your parents.
Death and dying.
Okay, well, welcome everybody. This is going to be an elder law seminar, and we're going to have some fun. We're going to learn a lot today. I'm going to talk for about an hour and a half, and then after that I have lunch for everybody here today. I know that's what you came for, but you still have to wait the hour and a half. I'm very sorry. Okay. Couple things. Number one, we are filming here today because we're going to put this on our website, and the entire seminar will be available for everybody. And if your husband or wife doesn't know you're here, you might want to duck down a little bit. Okay. What were you doing at the Bellport Country Club? In any event, in your packets are some blank pieces of paper. There are pens on the table. Take notes. One of the things I do is I don't take questions while I'm speaking. However, at the end of the formal presentation, I'm going to go to each table, and that will be a time where you can ask me anything you want, and I'll answer anything that I feel like. Is that okay? Fair enough? All right. Also in your packets, there's an outline. I don't follow it. However, there's a lot of numbers I'm going to be throwing around here today. They're in there. You can refer to it when you get home. But I don't follow it particularly. I get up here and I just start talking, and you never know where I'm going to end up. All right? So you ready? Yes. Okay, here we go. What elder law is all about is addressing the specific legal concerns that seniors may have. Seniors want to know, how can they manage their assets if they become incapacitated? How do you manage your medical decisions if you become incapacitated? Do you need a will? Is the will you have now okay? Should you be updating those wills, or should you be avoiding probate altogether? How do we minimize estate taxes? That's all under the elder law umbrella. But perhaps what elder law has become best known for, well, when I first started doing these seminars, I used to call it the $64,000 question. Wasn't that cute? But now, a few years later, 30 some odd years later, I'm now calling it the $200,000 question. And that is, God forbid we ever had to go to a nursing home, how are we going to afford the $200,000 a year that it costs without losing our homes and everything we worked a lifetime to acquire? Is anyone interested in this? All right, I'll stay. I'll stay. Oh, by the way, I don't know how to use this. Does anyone know how to use it? Because apparently you have to turn them off during seminars. All right? And I'm not sure how to do it. And if you don't know how to do it, if you could ask the person next to you, I think what you do is you just maybe press a button here, or you can silence it over here. So if everybody can figure it out. And I know what some of you are thinking, no one's going to call me today. No one ever calls me. Today they're going to call you. All right? And if they call you, if that thing rings, I'm going to make an example out of you. So please turn off the phones. All right. So why do we worry about paying for long-term care? Medicare pays for nursing homes, right? No. Medicare pays for a nursing home, right? No? Well, yes, Medicare does pay for a nursing home, but first you have to be where? Where? You have to be where? 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 That's not a where. A hospital. Who said that? Everyone's pointing it wasn't me. Okay. This is going to be tough. You ready? He said it. For how many days do you have to be in the hospital? Who are you looking at? For how many days do you have to be in the hospital? 3 days. You first have to be in the hospital for 3 days, and upon getting out of the nursing home, you have to be in the hospital for 3 days, and when you get out of the hospital, you have to get into the nursing home within 30 days, and in the nursing home, you have to receive skilled care that's rehabilitative in nature. And if you pass that very strict test, Medicare will pay fully. Right? They'll pay fully for 20 days. 20 days. And then from day 21 through 100, you still have to pay, but there's a coinsurance of $194.50 a day that you have to pay. And from day 100 and thereafter, how much does Medicare pay? Zero. If you go directly from your home into a nursing home, how much does Medicare pay? Zero. And if you're first in the hospital, you're there for 3 days, you get out of the hospital, you get into a nursing home within 30 days, but all you need is help with the activities of daily living, helping walk, eat, getting out of a chair, getting to the bathroom. How much does Medicare pay? Zero. The care must be skilled. That means you got a nurse helping you out. It's rehab. Medicare was designed, after you get out of the hospital, to get to a nursing home, to get rehab, to send you back home. That's it. And that you're not guaranteed 20 days, you're not guaranteed 100 days. You're only guaranteed up to 100 days to the extent you need rehab. They may come to you after 10 days, I'm sorry, Mrs. Jones, but you're not progressing. You're not taking advantage of the rehab that we're giving you. Your Medicare stops after day 10, or day 30, or day 50, or day 80. But even if you get up to 100 days, it stops after the 100 days, and then you're on your own. And the average cost of a nursing home per year is what? About $200,000. And the average stay in a nursing home is how long? 3 years. So the average stay of a nursing home here on Long Island is $500,000 to $600,000. And Medicare cuts out at day 100. So clients come to me and say, Lawrence, we don't want to pay for it. Find someone else that'll pay for it. Well, we all know you can buy long-term care insurance, and I bet some of you have it. I bought it for myself when I was 45 years old. I believe very strongly in long-term care insurance. But what's the problem with it? It's too damned expensive. That's the problem. I recommend it. It's the first thing I talk to clients about. But for the most part, if you're middle class, even upper middle class people, as you get older, it becomes unaffordable. Unaffordable. It's not a great product. It's the best product out there. I like you to buy long-term care insurance, but most people can't afford it and can't get it. And if you have some pre-existing condition, they won't sell it to you. When they smell smoke, they don't sell you fire insurance. When they see you have a little osteoporosis or a little arthritis, they're not going to sell you long-term care insurance because they figure you're going to need help someday. As soon as they think you may need help, they're not going to sell it to you. So if long-term care insurance is not an option on the table, what's left? Medicaid. Now, Medicaid is very different than Medicare. Medicare, you all understand. You got at 65, they give it to you as long as you participate in the Social Security system, right? Medicare is great, and it pays for doctors and it pays for hospital stays, but it doesn't pay for nursing homes. But you don't have to be poor to get on Medicare, right? As long as you participate in the system, you get your Social Security, you get your Medicare, and life is great. But Medicaid is very different. Medicare is national, it's federal. Medicaid is state and county. And you have to be what to get on Medicaid? Poor, destitute, got nothing. How much money can you have to get on Medicaid? What's the most amount of money you can have to get on Medicaid?
14,000.
There's been inflation, didn't you know?
30,000?
$16,800. And by the way, that includes the value of your home. If you need Medicaid, the most amount of money you can have is $16,800, and that includes the value of your home. We believe that will be going up, by the way, to $28,000 by January. Big deal. But there is one major exception I want you to know about. And it could be one of the biggest things you own. Anyone guess what it might be? Your house is not exempt. In fact, if you're not married and you own a house and end up needing Medicaid, Medicaid will put a lien on your house until it's gone. One good news is if you're still married and you're in a nursing home and you have a spouse still living in the house is an exempt asset. Okay? But you really got to be poor, $16,800, but there's one big asset that you're allowed to have. It doesn't count as an asset, and that is your, that's right, your retirement plans. Your IRAs, your 401ks, your 403bs, all of your retirement plans are exempt as an asset. You could have $1 million sitting in an IRA. It is exempt. It doesn't count toward the $16,800 that you're allowed. You would still be eligible for Medicaid, but your income must still be paid to your care, to your nursing home, to your home care. You still need to use your income, and your income includes the required minimum distributions from your retirement plans. And by the way, Medicaid has their own RMDs, required minimum distributions, which are higher than what you're used to from the IRS. But whatever it is, your income has to go to pay for your care. If you ended up in a nursing home for 3 years, they would get your Social Security, your pension, and your required minimum distributions from your retirement plans, but all the money in those retirement plans otherwise would be exempt. If you end up in a nursing home for 3 years, they'll get 3 years of RMDs, and the rest of your assets would be protected. Isn't this great? Are you having fun yet? This is a good message I'm giving you here today. All right, wait a minute. You're only allowed $16,800. You could lose your home. That's not good. So what if you do this? What if you do this? What if you take your house and you take your money and your CDs and all the money you have, your mutual funds, you just get it out of your name and you just give it to your kids. And by the way, they'll take it. But if you get everything out of your name today, you're now poor. You've got less than $16,800. Are you now eligible for Medicaid? Let's do that again. Are you now eligible for Medicaid? Yes.
Really?
Yes, immediately eligible for Medicaid.
All right.
No way. You're not eligible for a long period of time. Don't listen to him. Yes, you're immediately eligible. I know what I'm talking about. Don't listen to this guy. You're not eligible for a long period of time. Why do I sound crazy?
I don't know.
Because I am. Because there's two types of Medicaid. And I make all these jokes and these silliness because I'm trying to make a point here, and I want you to walk away really knowing this. And that is there are two types of Medicaid. One is Medicaid that will pay for a nursing home, and one is Medicaid that will pay for everything outside of a nursing home. Does anyone know what we call that, outside of a nursing home? That's called Community Medicaid, which includes home care. And here's what I want you to know. When I'm speaking here today, if you give away all your assets today and apply for Medicaid tomorrow, for Medicaid to pay for Community Medicaid, Medicaid outside of a nursing home, Medicaid at home, and aid coming into your house. There is no penalty at all for transferring away your assets. All you have to do is get the money out of your name. Lots of ways to do it, and we can teach you how to do it. But you get your assets out of your name. The next day you're poor. You are now eligible for Medicaid. If you know somebody who's home right now who needs help, who needs an aide to come in, whether it's 2 hours a day, 5 hours a day, Monday through Friday, maybe 7 days a week, maybe 24/7 in some cases. If you know somebody that needs help in their home, we can get them on Medicaid. You can protect all of your assets, even all your income. Isn't that amazing? And very few people know that. But you're not going to know it for long, because they changed the rules on us again. And here's what they did. They created a 2.5-year problem for us. As of October 2020, they created this 2.5-year problem. I'm going to call it a problem for now, because I don't want you to, I'm going to introduce another concept very soon. 2.5 years. But because of the COVID crisis, the federal government told the states they can't implement it yet. So since October 2020, when we're supposed to have this 2.5-year problem, it doesn't exist yet. Last thing we heard, they may not implement it until October. And even then it might get postponed. But October 1st right now is the deadline. Which means if you know somebody who's at home right now, who needs help, even just a little bit of help, we get the assets out of their name now. There's no penalty for doing that. We immediately apply for Medicaid. We get Medicaid. We get in the system. We get grandfathered in. All we have to do is get in before right now, October 1st. You apply now. Get it over with. Because if you apply after they change the rule and you have assets, I can't protect it all at the last minute. Now we're going to have problems. But if you apply before 2.5, even people who only need 2 hours a day, get in, get the 2 hours a day, so that as this person ages and needs more help, you're in the system, you just keep getting more and more care as time goes on. Got it? One of the most powerful things I want you to know about today is that you get rid of all your assets today, apply today. You can get help in the house right now. But if you're asking Medicaid to pay for a nursing home, then there is a penalty for giving away your assets. The penalty is not a dollar amount you have to pay, but rather an amount of months that you have to wait before you're eligible for Medicaid. How many months, people?
60.
There's a bold man. Let's vote, because I'm in a good mood today. I like voting. You ready? Who says it's 60 months? 5 years. That's the penalty. Raise your hands high if that's what you think. Hands down. Who says it's 3 years? Interesting. Who says it's 7 years?
What I feel like.
That you feeling like 7?
Yeah, that's it. I don't know.
Who says I have absolutely no idea?
All right, I don't know.
Okay. Hands down. And lastly, who says I don't give a damn, I came for lunch? I'm on to some of you. Oh, I heard Lawrence is entertaining and he feeds us. All right. All right, who said 5 years? Hands up high, I want everyone to see you. Feel bold, feel proud, because 5 years is the most common wrong answer. Congratulations. Well done, everybody. 7 years is becoming the second most common wrong answer.
Ooh, it's 10.
Would you like to know the answer? I'm sorry, I'm out of time. Have it. It was very nice of you to come. The actual answer is, it depends.
Oh.
That's a lawyer's answer, isn't it? It depends on what? How much money you give away.
Oh, really?
Really? How much money you give away. The real rule, the real penalty I'm being very particular here. But the penalty is that for about every $14,000 you transfer out of your name, you are not eligible for Medicaid for 1 month. I'll repeat it. For about every $14,000 you transfer out of your name, you are not eligible for Medicaid for 1 month. That's the penalty. Let me give you an example. If all you have in the world is $140,000, you transfer the $140,000 to your children. What's your penalty? 10 months. Got it? You give away $1,400,000. It's 100 months. You just take you give away a $240,000 house to 20 months. You take the value of what you give away, whatever it is, you divide it by about 14,000, you come up with an amount of months. It's that simple. Isn't this fun? Who said 5 years? Who said 5 years? Notice there's less hands going up than before. Because 5 years was pretty close to the truth. And now I'm confusing you again. And I'm being very technical here right now, but I want you to know there's a difference between the penalty and the there's another word I'm looking for.
Reality?
And the look-back period. The look-back period. You see, it used to be, you go, knock, knock, knock. Hello, Medicaid. I'm here for unlimited funds to pay for my nursing home. I'm poor. And Medicaid says, I bet you gave everything away to your kids yesterday, and you come in here and you're saying you're poor, just like you could do with home care. And the person would say, yes, that's correct. So they said, you know what? We're tired of you people doing this. You're manipulating the system. So we're going to give you a look back, a 2-year look back. We're going to audit your books. That's what the look back is. It's the audit period. The audit period. We're going to go back 2 years. So what did I tell my clients? I'd say, get your assets out of your name, wait 2 years, and then apply for Medicaid. Knock, knock, knock. Hello, Medicaid, I'm here. I'm poor, and you can see, if you audit my books, that I've given nothing away in the last 2 years. And they had to give them Medicaid. So Medicaid says, we're going to make it harder. We're going to make it 2.5 years. Then they made it 3 years. And now it's a 5-year look back. It is an audit period. If a transfer is caught in the look back, or if there are transfers caught in the look back, you add them all up and you divide it by 14,000 to come up with the penalty. So let me give you an example. Let's say 3 years ago, you write a check for $140,000 to your children. 3 years later, you end up in a nursing home. Are you now eligible for Medicaid? What do you think? Yes or no? And the answer is, no, you're not eligible for Medicaid. So let's go through the test. Number one, you're in the nursing home, you're poor, you apply for Medicaid. What is the look back? 5 years. Was there a transfer caught in the look back in this example? Yes, aha, Medicaid says. We see you gave away $140,000 3 years ago. You're going to be penalized for giving away that $140,000, and the penalty is 10 months, because you take the $140,000, divide it by the $14,000, and you're going to come up with 10 months. Okay? So there's a 10-month penalty. When does the penalty begin? It used to be years ago that the penalty began when you gave away the money. So if you're applying 3 years later and the penalty started 3 years ago, your penalty's over, you're eligible for Medicaid. They stopped people from doing that. And they said, from now on, your penalty will begin the first day you're in the nursing home and poor. So when you apply, you're in the nursing home, you apply for Medicaid, they see that $140,000 was transferred within the 5-year look back. You have a 10-month penalty. It starts the first day you're in the nursing home, which means that the first 10 months of the nursing home, you can't get Medicaid. But Medicaid will kick in after the 10 months. How will you pay for the next 10 months? Well, you just get the money back from the kids. But even if your angels will do that and they'll give you back your money, you're just going to spend it on the nursing home because the next 10 months is going to cost you 140 grand. So you've just lost all your money. You didn't protect anything. The only true way to protect 100% of what you want to protect is to get those assets out of your name, get your 5-year look-back started, and get your 5-year look-back over with. If the 5 years is over, your assets are protected. Now, I can save 35 to 50% of the money at the last minute. I'll show you how I do that. So let's say all you have is, let's go with $140,000. You end up in the nursing home, $140,000. You're not eligible, right? Because you can only have $16,800. You're paying attention. All right, what if you do this? Let's take half of that 140. We're going to give 70 to the kids. What's the penalty for doing that? If 10 months was for the whole 140, half would be 5 months. All right, so you give away half of it, $70,000 to the kids. That will give you a 5-month penalty. I'm going to simplify this in a second. The other half of the money will pay for the nursing home for the 5 months. And at the end of the 5 months, your penalty is over, you're out of money, you're eligible for Medicaid, you saved half of it. It's more complicated than that. I'm not going to get into why it's more complicated, but the bottom line, that's the concept, is that you give away half and the other half will finance the other half, or the penalty period. So even at the last minute, we can save a lot of money. But if you want to save your whole house, if you want to save a whole asset or assets, if there's assets you absolutely want to protect, 100% of them, you got to get the assets out of your name, get your 5-year look back started, get your 5-year look back over with, and those assets will be protected. But I want to make something perfectly clear. I am not here today advocating that every one of you should be transferring away all your money to your kids. Because there's something more important than saving money and getting on Medicaid, and that's preserving your dignity and your independence and your control over your own life. The only one I didn't give that advice to in my life was my father. He was on to me. All right. But if your goal, and I'm not saying it should be, because you're all going to have different ideas about all this. You grew up differently. You have different value systems with money. You have different dynamics with your children. All of those things make you the crazy people we all are. We all have different attitudes about this. Even a husband and wife have different attitudes about money, as you all probably know. So there is no right way for everybody to be thinking about this. And I'm not advocating today that you should all be having the same think. Got it? But if your goal is to protect your assets for your children, even the people you like better than your children, which is your grandchildren, if your goal is to protect your assets, then you need to get your assets out of your name and get your 5-year look back started and get your 5-year look back over with. Now, who we're going to give the money to, whether we're going to give it to the kids or not, or we're going to give it to something else, a trust, life estate, all these other things that I'm going to be talking about today. I'm going to talk about that in a minute. How we get the money out of your name. What's the best tax way to do it? I'm going to talk about all that. But there's another scenario I want to get into where we can actually pull a rabbit out of the hat at the last minute. So let's say we have a husband and wife. By the way, it could be a wife and wife, a husband and husband, doesn't matter, it's the same rules. Common denominator, husband and wife. Husband gets sick, let's give them some money. They have a $400,000 house in Bellport. Actually, that doesn't exist. Let's call it a $600,000 house. All right, so let's say there's a, does that exist? That still exists here, right? So a $600,000 house here in Bellport, jointly held between husband and wife, and let's give them $200,000 sitting in the bank. Okay? That's for Long Island. That's in Bellport. That's a middle-class couple, right? By the way, we represent in our firm the most affluent people on Long Island doing very heavy estate tax planning. I'm not going to be talking about that part of my practice today, because that's for the really wealthy today. If you've got under 12 million, you have no federal estate tax. If you have under 6 million, you have no New York tax. If you want me to do a seminar for people with more wealth, happy to do it anytime. We have lots of clients to do that. But the vast majority of my clients, my elder law clients, are not rich, because the rich people can pay for their care. They don't come to seminars like this. They don't come to an elder care seminar trying to figure out how to protect their assets from a nursing home, because they can pay for it out of their interest. They don't care. The problem of paying for nursing homes is a middle-class problem, a working-class problem, even an upper-middle-class problem. And so and that's the vast majority of my elder law clientele. So I'm not going to talk about that. So the examples I give tend to be more modest numbers. But don't mistake the fact that we don't do all that high-end estate planning. So we have a couple, they own a $600,000 house jointly held here in Bellport, and $200,000 in the bank. Could be 500, could be $1 million in the bank, it doesn't matter. Example here is 200,000. Husband has a stroke and he ends up in a nursing home. By the way, in all of my examples today, the husband is going to get sick first and the husband is going to die first. Why do the men die first? Because they want to, that's correct. I apologize to the women in the room. All right. Husband got sick first, he ends up in a nursing home. Is he eligible for Medicaid?
Depends.
Is he eligible for Medicaid today?
Oh, no, not with a...
Is the house a problem? It's a $600,000 house. Isn't that a problem? Yes or no?
Yes, unless it's out of his name.
The answer is no. As long as the spouse is living in the house is an exempt asset. I told you that already. The house is exempt. I don't care about the house right now. Of course, if he dies and she ends up in the nursing home, we lose the house. So we really want to do planning for both of them. But right now, we're in a crisis. The client didn't do anything. They're sitting there with this jointly held house. It's exempt because she's living in it. Now we look at the $200,000. Does that present a problem? Yes. How much money is he allowed to have in his name? $16,800. That's correct. $16,800, and he's got at least joined on a $200,000 bank account here, or a brokerage account, or whatever they have. So he's not eligible for Medicaid yet. All right? What if we do this? What if we take the money? Let's say he takes the money, or they take the money, and we transfer the money and the house. We get everything out of his name, and we put it into her name. By the way, he thinks Nixon's the president. How did we sign his name to transfer all this money over to her? We forge it like we always do. No, that was the wrong answer. Practical, yes, but the wrong answer for right now. What does she need? A power of attorney. What type of power of attorney? A durable power of attorney. What does that mean, a durable power of attorney? It means the power of attorney says it's still good if he becomes incapacitated. One line. That's all it is. It hangs in there. It's still good. If the principal becomes incapacitated, the agent normally would be incapacitated as well, but because it's durable, it hangs in there, it's tough, and the agent can still act for them. So they have this store-bought power of attorney. They got something on the internet. They have this power of attorney. It appoints the wife to make all of his financial decisions. Can she use it to transfer all the money out of his name and put it in her name?
Yes. Yes.
Absolutely not. Because an agent is not supposed to steal the money. And what is she doing? She's taking all the money out of his name and putting it in her name. That's stealing it. She has to do what's in his best interest. But if the power of attorney specifically says that the agent can make gifts of the assets, and it goes further, not only can they make a gift of the asset, but they can self-deal. They can actually give it to themselves. They can steal it. Then the agent, the wife here, would have the authority. So as long as they have a really good power of attorney, a really good durable power of attorney, then the wife here can take the power of attorney, get the house, get the money, everything out of his name. Now she's got the money, she's got the house. Is there a penalty for giving it to her? Well, there might be. She's got the house, she's got the money. The next thing you know, she's in Florida with a neighbor. That's terrible. That's terrible. That didn't happen. All right. So is there a penalty for giving her the money in the house? Is there a look back? Is there a penalty? Is there some period of time we have to wait? And the answer is no.
What?
No. No penalties between spouses. Unlimited amounts can go back and forth between spouses. No penalties at all. Okay? Good to know. So that you take the money, she takes the house, she uses the power of attorney, she gets it all out of his name, she puts it into her name, he now is poor, there's no penalty. Is he now eligible for Medicaid? What do you think? Yes. Absolutely not.
No.
Not yet. Because Medicaid's going to say, lady, you got too much money. You got too much money. You remember those I do's? In sickness and in health, you're supposed to pay for him for his health care, and vice versa, by the way, with all these examples. You're supposed to pay. She's going to call up Medicaid. Medicaid, are you kidding? I have to pay for him? There was no penalty for me to get it? Sorry. The advice that we're going to give you today from Medicaid is that you are not eligible for Medicaid, or he's not eligible, and you must spend down your money until you're down to about $134,000. She's allowed $134,000. She might have been starting at $1 million or $200,000 in our example. She has to spend the money on his nursing home until she's down to $134,000. That is the advice she's going to get from Medicaid. But I want everyone to repeat after me. You ready? Medicaid.
Medicaid
is the enemy.
enemy.
You don't listen to your enemy when you're trying to protect your assets. This is warfare now. You listen to Lawrence Davidow. You listen to Lawrence. Anyone getting my listen to Lawrence emails now? Yes. Oh, good. You listen to Lawrence. And what Lawrence is going to tell you about that Medicaid's not allowed to tell you about is something after all these years I'm still calling the Nancy Reagan exception. What was she known for having said? No. No. Sorry, Medicaid. No. I am not paying for him. I refuse to pay for him. And what the wife is doing here is technically called spousal refusal. And this might be something the husband already knows about. Let that one go. All right. So she refuses to pay for him. Now he gets Medicaid. She could have $1 million. She refuses to pay for him. He gets Medicaid. Medicaid, however, has a right to sue him.
Oh, Lord.
Sue her, sorry. Sue her to support her husband, which they have never done in Suffolk County. In my 35 years of doing this, they have never done it in Suffolk. They did it in Nassau for a little while. Maybe 3 or 4 years ago they were doing it. They stopped. Sometimes upstate, sometimes in the city they do it. They're testing the waters, but they stopped. Suffolk has never done it because it's bad public policy and bad politics to impoverish that little old lady and have 2 old people on Medicaid eventually, dragging her into court and taking away the last dollar she has. It's bad politics, it's bad policy. So they don't bring these lawsuits. So she's sitting here with a house, she's got $1 million, $200,000, whatever she has. She does spousal refusal, he gets Medicaid. End of story for now. And I know what you're thinking. I'll be the first. They're going to sue me. Well, maybe, but I doubt it. But I have been predicting the end of this for 35 years. Every year, it's got to go. Can't believe they allow us to do this. Within 3 years, it'll be gone. Well, I've been saying that for 35 years. Still here. Every year, they bring it up in the budget to get rid of it. Still stays. Because it's bad policy, bad politics in the end. But they keep bringing up the idea of stopping this spousal refusal thing. So we have it for now. If you know somebody, if you know a couple, and one is in the nursing home and they're paying for it, you don't need to make another payment. You don't need to make another payment. Spousal refusal, get Medicaid to pay for it. Even if Medicaid were to sue you, you only have to pay back Medicaid what Medicaid paid the nursing home, which is far less than the private pay rate. So you'd always do it that way. Okay? Are we having fun now? Bottom line, though, have you learned anything yet?
Yes.
All right. Because my father was the lawyer, my grandfather was the lawyer, my sister, my uncle, we're all lawyers. But my mother was a kindergarten teacher, Patchogue Medford. And she says, don't talk like a lawyer. Talk like a kindergarten teacher. Make people understand you. Tell a story. And I hope that I'm making my mother proud today. All right. All right. Now, you understand now that there are these rules of moving assets around. There's times that you have to get them out of your name. You get all that. Those are the basic criteria to be eligible for Medicaid. The next step in our understanding here today is who are we giving the money to? Are we just going to transfer the money to our kids? What's the answer? No. So we've got to do something to protect ourselves. Now, the asset that most of my clients are trying to protect is the house. The typical client I have is a middle-class, working-class person who's concerned about losing assets. And what are the assets they have after living here on expensive Long Island? They've got a house that maybe got paid off after 30 years, and they have an IRA. Forced savings, because this is a very expensive place to live. What you're forced to save, you're able to save. It's hard to get anything else, unless you get an inheritance or something. Everything's so expensive here. So if the IRA is exempt, we don't have to worry about it. But the house is not. You could lose your house. And the house is the most popular. It's what I get the most questions about. 95% of the people who come to me to help them protect their assets are coming in to protect their house or houses. But also we could save stock in mutual funds and CDs, or whatever it is you want to protect. But let's just start with the house. I'm going to teach you now how to protect your house and how not to protect your house. And here we go. So let's say you bought your house here in Bellport 30 years ago, and you paid, I don't know, let's say $100,000. Put your own numbers in your head. You paid $100,000. What you paid for your house, what is that called in tax law? Basis, that's right. That's where you start from, your base. And through the years, we'll give a modest number here. Oh, it doesn't matter. You put another $200,000, that's not modest, but $200,000 you put into the house. Okay? New roof, new kitchen, new bathrooms, new siding, new I don't know, you put a lot of money into this house. New pool, whatever it is. So you add what you paid for it, plus what you put into it after that, and that's called your basis still, or your adjusted basis. Now, the house, let's say your basis is now, doesn't matter, 200, 350. Your basis is 350. But you sell it for you could sell it for 600,000. The difference between your basis and what you could sell it for is what? Your profit, or what we call the capital gain. That's right, the capital gain. Now, if you were to sell your house and you had a $250,000 capital gain, would you pay any tax? Yes. And the answer is no, because it's your principal residence. And if it's your principal residence, you get an exclusion from paying capital gains of how much? $250,000 per person, $500,000 for a couple. So if you sold this house and you had $250,000 of capital gain, you wouldn't pay any tax, whether you're single or married. All right? But the problem is that the kids came over last weekend. Mom, Dad, we love you. But we're very concerned about you. We're very concerned that You could get sick and you could lose your house. So we have a great idea. Why don't you transfer the house out of your name and just put it in our name, and we'll let you live there for the rest of your life? Isn't that a great idea? I'm going to arm you with the right answers now. But there's really only one answer. What's the answer? No. No! Never, ever, ever, ever put your house in your kids' names. Your house is precious to you. It's the roof of your head. It's your shelter. It's your sense of stability. Never lose control of your house. But I love my son. I trust my son. So you give your house to your son, the next thing that happens is he dies, and now your daughter-in-law owns the house. And what's worse than that? She remarries a lawyer.
And you're out.
Sorry, Grandma, you got to go. Never lose control of your house. But even if you don't want to explain that to them, there's tax reasons. That capital gain we talked about, that $250,000 of capital gain, your basis and that fair market value, the difference. If you give the house to your kids while you're alive, you're giving them your basis. So when they go to sell the house, either during your lifetime or after your death, they have to pay the capital gain. But they don't have the $250 exclusion because it's not their principal residence. So giving the house to the kids is a disaster for tax purposes as well as control. The other thing is, what else will you lose if you give the house to the kids outright? Your star exemption, your enhanced star exemption, your veterans, your senior exemptions, your write-offs. All your taxes are going to be much higher. You're going to pay double in taxes, many of you. So there are many reasons why we never put the house in the kids' names outright. Even though if we did, 5 years later, 5-year look back, the house would be protected. We just don't do it, and I won't let you do it. All right, then we need to figure something else out. But by the way, did you know this? If you own your house and you die owning your house, basis, remember, it's worth this. If you die owning your house, whoever inherits it gets a new basis equal to the value of the date of death. We call this the step-up in basis. Step-up. It steps up to the value of the date of death. If at the time of your death, your house is worth $600,000, then your basis becomes $600,000. And if the kids sell it after they inherit it, they get the step-up in basis. They sell it. They have nothing to pay in capital gains tax. Death is the best tax shelter. Because if you die owning an asset, house, stock, all the capital gains will get wiped out. Okay? All right. But holding on to the house so you can get the step-up doesn't work because you end up in a nursing home, they're going to put a lien on the house until it's gone. That didn't work either. So we have to find a way to get the house out of your name. Get your 5-year look-back started. Get your 5-year look-back over with. While at the same time, keeping you in control of your house, keeping all of your property tax exemptions, and still getting the step up in tax basis. In other words, if you're like the rest of my clients, you want to have your cake and eat it too. Correct? Yep. Isn't that what you want? Yep. So there are 2 tools in the tool shed. So I'm going to describe these 2 tools, but as far as I'm concerned, they're just a saw and a hammer. One is not necessarily better than another in the abstract. Depends on what we're trying to accomplish, depends on your situation. I'm not advocating that one or the other is better for you. In fact, I am not necessarily advocating that either one of them is right for you. Okay? Remember that as I describe them. I'm not selling them. All I'm doing is describing them and some of the pros and cons. Many of you, I'd say you don't need either one. Some of you may need one. Some of you may need the other. Okay? Now, what are the 2 tools in the tool shed that we use? You got it. Trusts and life estates. And I'm going to describe those 2 tools. Let's do a life estate first. You ready? This fun?
Yeah.
You learning?
Yeah.
Okay, let's keep going then. If you stop learning, kick me out of here. A life estate is when you do a new deed to your house. You transfer the house to, let's say, your kids. Could be nieces, nephews, stepkid, doesn't matter. But let's say you want to save the house for the kids. You're transferring the house to the kids, and in the body of the deed, you are reserving the right to live there for the rest of your life. In other words, the kids own the house, but they're stuck with you. Because you have exclusive occupancy. They can't move in with you. They can't sell it out from under you. You're in control of your house, but only for your lifetime. And upon your death, your life estate goes poof, it extinguishes. The kids own the house, no probate, they automatically own the house, nothing more to do, they already own it. Your life estate is gone because it was only for your life. You keep all of your property tax exemptions. You keep all of your write-offs. Nothing changes in your life. Nobody can kick you out. This is great. And when you do it, after 5 years, your house is protected from Medicaid. Boy, does that sound good.
Well,
What do you mean, well?
it's not.
Doesn't it sound good?
Yeah.
Sounds good, right? He says it sounds very good. He's the authority. It is good. It's a good tool. It just won't work for a lot of you. It's not the right tool for a lot of you. Because what's the problem? Can anyone think what the problem might be? Kid dies, it goes by his will to probably his wife or husband. So you may not want it to go to them, but you may want it to go to the grandchildren. That's an issue, but that's not the real problem. Here's the problem. The real problem is you wake up one day, your back hurts, you got a 2-story house, it's hard getting up the knees. I just had knee surgery myself. The knees hurt. Can't take care of the garden anymore in the back.
Oh, no.
The neighborhood is changing. I don't want to live in this house anymore. I want to go anywhere but my kid's house. I want out, though. I just got to get out of this big house. Too many memories. It's just too hard to take care of. I want to sell my house. Can you? Well, I'll tell you this. Who owns the house? Who owns the house? Who owns the house? You keep saying the kids, and it's the wrong answer. It's not a complete answer. Who owns the house? Who owns the house? You and the kids. You and the kids. You're back alive again. She wants to move out. So she has to go to her kids and say, kids, I want to sell the house. I need your consent. Let's assume that's not a problem. Let's assume that's not a problem. You go to your kids and say, I want to sell my house. I've got to go here. I want to go there. I need to go to assisted living, nursing home, whatever it is. I want to sell my house. They're probably going to say, sure, whatever you want, Mom, Dad. Okay, you sell the house. You all go to the closing together. You all sign off on the thing. And who gets the money?
Kids? Oh, both of you.
That's the trick. You both get the money because you're all the owners. What percentage do you get? Well, the value of your life estate. What's the value of your life estate? There's an IRS table that gives us a percentage. And it depends on how old you are. The older you are, the less your life expectancy, and therefore the less the value of your life estate. There's a table, okay? So let's say you're now 80 years old, you want to sell your house, and let's say that you go look at the tables, and the tables say that your life estate is worth, let's say, 10%, and what the kids have is 90%. So 90% of the money goes to your children.
Jeez.
Now you may say, that's not a problem. They'll give it back to me if I need it. Let's assume that's true, which is not true for everybody here. But let's assume that's true. The problem is that the kids own 90%, which means they have to pay 90% of the capital gains. No exclusion. The 10% going back to you, you get to use your 250 exclusion. You won't pay tax on your 10%, but the 90% they're getting, they're going to have to pay huge capital gains tax. The other problem is you are going to have to get back your 10%. Oh my God, it's like a hot potato. You just spent over 5 years getting rid of it. And now you're getting back 5%. What do I do with it? Kids, take my 5%. Another 5-year look back. Or if the reason you're selling the house is because you need to go into a nursing home and apply for Medicaid, you're just going to say, here, Medicaid, take my 10%. We never, ever recommend life estates for clients who want the flexibility of selling the house while they're living. Because it's a disaster if you sell it while you're living. Okay? So this is what happens too. I go to a couple. You ever going to sell your house? And they look at each other, and they look at me, and they say, absolutely not, we'll never sell the house. I go to the husband. If she dies, what are you going to do? Sell it in a minute. I've been wanting to go to Florida for years, and she makes me stay here for the grandchildren. Okay. In other words, the right answer is, when I ask you, you ever going to sell your house, the right answer is not no usually. It's I don't know. And if you don't know, you need the flexibility. And if you need the flexibility to sell it during your lifetime without problems, then don't do a life estate. It's the wrong tool in the tool shed for you. But if you say, look, you know, my kids live nearby, if I'm not, I'll never sell the house while I'm alive. If something happens to me, they can take care of it. They'll rent it out. They'll put a grandchild in there. They'll move in themselves. We'll never sell the house while we're alive. I'm willing to sign that in blood. Then a life estate is an appropriate tool in the tool shed. Okay? All right. Moving on. Let's talk about trust. How many of you here have ever even seen a trust? All right, maybe 10, 15% of you. All right. So I'm going to give you the Davidow School of Law Trust 101 class. You ready? A trust is a contract that you make with somebody you trust. That person you trust is called the trustee. An executor is in a will, a trustee is in a trust. It's a contract you make with somebody you trust for that trustee to hold your assets for you, whatever assets you want to give them to hold. And the trust contract will say what they can do with those assets while you're living and who they should give those assets to after your death. That's all it is. It's a contract for trustees to hold your assets pursuant to the trust contract. Now, there are two types of these trusts. Remember, it's a contract. If you reserve the right to undo the contract at any time, that will be called a revocable trust. If the trust is somewhat set in stone, where you can't undo it, that will be called an irrevocable trust. Now, when you and the trustee sign the contract, it brings to life a new entity called a trust, whether it's a revocable trust or an irrevocable trust. Okay? When it's first born, it doesn't own anything. There's nothing in it. It doesn't own anything. It's all about title, about ownership. So, if you want to save your house, you would have to do a new deed, transferring the house out of your name into the name of the trust. If you're trying to protect your CDs, your mutual funds, you change the title out of your name into the name of the trust. Perhaps my trust would be called the Lawrence Davidow Trust. So I'd take my house out of Lawrence Davidow's name and put it into the Lawrence Davidow Trust, retitling it. Now let's say that I put my house into the Lawrence Davidow Revocable Trust. Okay, I put my house into the Revocable Trust. 5 years later, my house is protected from Medicaid, right? 5 years later, my house is protected from Medicaid, right? The answer is no. Revocable trusts do absolutely nothing to protect your assets from Medicaid. Why? Because you can revoke it, which means you really never gave the house away or the money away. If you put your money in a revocable trust and you can revoke it and get it back, you never gave it away. You never lost control of it. You just put it back in your name. That will not save a dime from Medicaid. It will not save a dime from taxes. There's only one reason that people create revocable trusts, and I write a lot of them. What is the one reason that people create revocable trusts? We don't go through probate. We avoid probate. Oh, I said it out loud. Everybody knows that the word probate is a sin. It's a terrible word. You got to avoid it at all costs. You have to avoid probate, right? That's what they say on television. You see these ads on television. You got to avoid probate. You're going to read stuff. Got to avoid probate. Best thing since sliced bread. A revocable living trust to avoid probate. Everybody has to avoid probate. Why? Because probate's expensive. And it will take years to go through probate. You got to do everything you possibly can to avoid probate. That's what trust salesmen say. Probate is not a sin. Probate is not a big deal, usually. In fact, the cost of probate will be somewhat similar to the cost of creating the trust in the first place, over just doing a will. Now, there are clients that say, thank you for that, but isn't it a little easier? Won't it be just smoother, easier transition to avoid probate? The answer is yes. It will take less time. But most probates don't take a lot of time. I will tell you, they've been waiting 80 years for you to die. They can wait another 4 or 5 months to get their money. And how much do you want to spend to make it easier for them? But I have clients out here, there's some of you in the room, and say, Lawrence, no. My goal, even if it doesn't save my kids a lot of money, I want to dot the I's and cross the T's. That's who I am. That is what I value. I want to make it easier for my spouse, for my kids. I want it to be very smooth and easy for them to get the money. Then a revocable trust is a tool in the tool shed. My real point is that it is oversold and not everybody needs one. But it is a tool that's useful and can save some time and can save a little bit of money. All right? Just not a ton of money. But there are cases where I think avoiding probate is essential. I remember the very first case that my father gave me when I got out of law school. Right here in Patchogue. I joined the firm and he says, here's your first case. It's a probate for Mrs. Smith, whatever her name was. She died. She was 90 years old. She didn't have any kids. She wasn't married. She owned a house in Patchogue worth $100,000 at the time. She had a friend in the last 10 years of her life that helped take care of her. She had a will already had been done where she had named her friend as the executor, and the friend was the sole beneficiary of the house. Go probate the will, Lawrence. Doesn't that sound like an easy will to probate? Yeah. Well, unfortunately, the law of New York says in order to probate the will, you must first notify everyone who's getting cut out of the will. Well, who's getting cut out? There's no kids. There's no spouse. There's no brothers and sisters. She died at 90. Her parents, her grandparents, they're all dead. Well, it turned out that this Mrs. Smith, her mother had 14 brothers and sisters. And her father had 13 brothers and sisters, 27 aunts and uncles, all dead, leaving hundreds of first cousins spread throughout the world. By the way, where was this family from? Originally. Italy. It could have been Italy. They were Irish, but it could have been Italy. It could have been Ireland. It could have been a Jewish family from Ukraine. Luckily, they were here. Mm-hmm. Hundreds of first cousins. We had to find them all. Took years. Years. Disaster. You have to find everybody who would have inherited. Instead, if Mrs. Smith had created the Mrs. Smith Revocable Trust and put her house in there and named her friend as the successor. See, you can be the trustee of your own revocable trust. So you're the trustee, and then upon your death, this next person becomes the trustee. They read the trust. It says, oh, I'm the trustee, and I get to take all the money, in this case. So she took all the money, and it was done. No probate, no notifying everybody. So if we identify that your will is more difficult to probate than the average will, then we should be avoiding probate. What are other circumstances? Well, if you've got real estate here in New York and you have real estate in Florida or somewhere else, you have to probate your will in every state you have real estate. So I don't want to probate in 2 states. So if I have a client that has real estate in 2 states, one of the tools we use is a revocable trust. We put the Florida property in, we put the New York property in, we put all the other assets in, and we avoid probate in 2 states. Makes sense. If you're treating your children unequally, and you know one's going to be mad about it, I don't want to be in court. I don't want to make it easy for them to contest anything. Stay out of court. Avoid probate. If you have a child with disabilities who can't sign their name, it's harder to probate a will because we have to protect the interest of that person with disabilities. Let's stay out of court. I want to get away from all those fancy rules. So I have to look at the case and see if your case is more complicated than usual, will take longer, will be more expensive, and then we can talk about a revocable trust. But don't have the knee-jerk reaction that everybody has to avoid probate and that everybody needs a revocable trust, especially in the world where it doesn't protect you from taxes and it doesn't protect you from Medicaid. That's my story of revocable trusts. But an irrevocable trust will protect your assets from Medicaid. And it has some advantages and disadvantages from a life estate. So let's do that. An irrevocable trust, you cannot be the trustee. So let's say you pick your kids. I have a Nicholas, I have a Ryan, I have a Rebecca. I love them, sometimes. Let's say I pick my 3 kids as trustees. I could have 1, I could have 2, I could have 3. I don't have to have any of them. I could have somebody else. I got to pick somebody. But if you don't trust your kids to be trustee, why are you trying to save all this for them in the first place? But let's say that's what you want to do. You pick, let's say in my case, Lawrence Davidow wants to save his house. I create the Lawrence Davidow Irrevocable Trust, and I put Nicholas, Ryan, and Rebecca in as my trustees. I do a new deed to my house. I transfer it into the Lawrence Davidow Irrevocable Trust. 5 years later, my house is protected. The trust says I have the absolute right to live in that house for the rest of my life. Nobody can kick me out. Nobody can sell the house out from under me. You keep all your property tax exemptions. At death, you still avoid probate, because irrevocable trusts avoid probate as well, and you still get that step up in tax basis. It does everything that the life estate did. What was the problem with the life estate, though? If you tried to sell the house while you're alive, you'd have all these tax and other problems. The irrevocable trust solves that particular problem, because if you give your consent, the trustees can sell the house. The trust will sell the house. The trust will get the money. You keep your $250,000 capital gain exclusion. We can sell the house at any time. Nothing, you won't pay taxes. The trust will continue to protect the money in the trust, and the trust can buy you another house. Can buy you into that 55 and older community, whatever it is. Or move to Florida, whatever you want to do. The trust sells the house, the trust buys the next house. No new 5-year look back. They only get 1 bite of the apple. When you put the first house in, that starts the 5 years. That house gets sold, it doesn't start a new 5 years all over again. So you go to your kids, sell that house, I'm ready to move. And the kids say, no way. We want this house, we're keeping this house, we refuse to sell it, Mom. Well, what can Mom do? Well, I want you to know, while you can't revoke the irrevocable trust, I do reserve for you the right to change the trustees at any time. You also have the right to change the beneficiaries of the trust at any time. So if your children forget your birthday, if you didn't like your Father's Day present this year, you can change the beneficiaries among your children and grandchildren at any time. If you can change the beneficiaries and you can change the trustees, who is in control of this trust? You are. That's why it's popular, because it's so friendly to you. Yet you protect your house and other assets for your kids. So the other benefit of trust over a life estate is not only can you save your house, but you could put CDs in there, you could put annuities in there, you could put mutual funds in there, money market, whatever you want to protect. But let me also make something perfectly clear. Yes, you could put every dime you have into the trust and you could protect it all 5 years later. But that's not what this is about. The best question is not how much you're going to put in the trust. The best question is how much you want to keep in your name to feel independent and secure for the rest of your life. It's not about saving every dime for the kids. It's about a balance. Balance. It's all about balance. You might want to protect something for your kids, and you want to protect something for yourself. Leave enough money for yourself. You're going to keep your pension. You're going to keep your Social Security. You're going to keep all your retirement plans and all the minimum distributions from them. How much more do you need? 100,000? 50,000? 500,000? Pick your number. Whatever you're comfortable with, and then everything else you put in the trust. And then my question is, if you put those assets in the trust, will it change your life? If the answer is, you know what, it wouldn't really change my life in any way, then I think that is appropriate. That's how I want you to approach it. Okay? All right. Are we still learning? Mm-hmm. A lot of stuff, huh?
Yeah.
All right. Just checking time. Oh, we're good. All right. All right. A couple of other topics I want to cover. You know, as an overall estate plan, you know you need some type of a will, maybe a trust, maybe not a trust. You need a power of attorney, a durable power of attorney with all that good stuff in it I talked about. You need a healthcare proxy to appoint someone to make your medical decisions. Perhaps a living will. That's different than a healthcare proxy. A living will says, hey, I want you all to know if I have some terminal condition, I have no hope of recovery, I don't recognize my family, I'm out of here. I don't want respirators, I don't want feeding tubes. Don't even put the spoon in my mouth and make me swallow the applesauce. I want morphine. I want lots of morphine. I want lots of morphine, and then I want to be pushed out to sea and forget about it all. All right? That's a living will. There is no living will law in New York. It's just guidance to your healthcare agent and to your family. That's critical to understand. You can't go into a hospital with your living will and say, pull my plug. Actually, you could, but your family can't. Okay? Only a healthcare proxy can make that decision for you if you can't participate in the decision. It's guidance. Why is it so important, though? Because when your kid is sitting around ready to pull your plug, it'd be better if they read the living will and heard your voice. It takes them off the hook psychologically. That's why it's so critical. Because then it's like you're really pulling your own plug. They're just your tool. Because many of you have lived through the death of your parents, and I know it. Both of the deaths of my parents still haunt me today, even though we did the right thing. But there's something haunting about it. And the more you can be taken off the hook psychologically, or your kids can, you're doing a great service to your family. All right? A lot of you have lived that, like I have. All right. All right. A couple of other topics, and then we're almost done here. By the way, anyone know my family? Anyone know my father, Wallace? Knew him? He died. You did? Or my uncle, Sanford Davidow? Knew Sandy? My mother, Norma Davidow? My aunt, Saundra? All right, just curious. I love coming back to Bellport because it is my home. And I see people I haven't seen since high school, well, maybe once or twice, but it's nice to be home. I learned how to play very bad golf right behind you here. All right. In any event, A couple of other quick topics I'd just like you to know about that are very popular these days. If you're in a second marriage, oh boy, these are tough. From an estate planning point of view, second marriages are tough. You could be married for 30 years to the second spouse. You die, you leave everything to the second spouse, the survivor, who then turns around years later and says, you know, his kids, they never call me anymore. I know I promised I would give half to his kids, but they don't deserve it. So what happens all the time in these second marriages, especially shorter ones, everything goes to the surviving spouse, him or her, and they take care of their own kids. They sometimes forget about taking care of your kids. This is very difficult and tough to talk about because the surviving spouse is saying, wait a minute, I need all the money to live. This is our standard of living. If you die, I need it all. So we have to find some compromise because you can't just turn your back on your own children. Well, maybe you can. And if that's what you decide, that's fine too. But usually we try to craft some type of a compromise. Very often what we do is first spouse dies, money goes into a trust for the benefit of the surviving spouse. So the surviving spouse has use of all the money. But when the second spouse dies, the money in that trust goes back to the spouse's first kids. Or some combination of a little bit to the kids, a little bit to the spouse and call it a day, or something like that. But it has to be addressed. And if you just do simple wills where everything goes to the survivor and their family wins. And you better hope that you married a good person. The problem is they are a good person when they said they were going to take care of your kids. And sometimes the body is still warm and they call me up. I need to change the will. Sometimes it's years later after the first spouse's kids haven't invited them for Thanksgiving dinner for 10 years or sent a birthday card. Things change. Protect your children. All right. Other quick topic. If you have a child or grandchild with disabilities, it may be that you cannot leave them any money. You may say, I don't have my grandchildren in my will. Most of you do, because you left everything to your children per stirpes. Does anyone know what that means? It's a Latin term that means per the root. Per the root. Per stirpes means if my child predeceases me, their share will go to their kids. And that grandchild of yours with autism will inherit money when perhaps they shouldn't. In fact, they may need government benefits themselves. They may need government benefits themselves. When they're 18, they may need SSI and Medicaid. A big part of my practice is dealing with families who have children or grandchildren with special needs. Very often they cannot inherit the money because if they inherit the money, they will lose the government benefits that they would otherwise get. So if you have a child or grandchild with disabilities, you should be thinking about incorporating into your will or your trust something called anyone know? A special needs trust. Or we call it a supplemental needs trust. Or for shorthand, we call it an SNT. But a special needs trust. Essentially what it is, it's a trust that says, I'm going to put this money in there for my child or grandchild. I'm going to pick a trustee, brother, sister, aunt, uncle, friend, lawyer, bank, somebody, to be the trustee. And the trustee will have full discretion to use the money for that child or grandchild with disabilities. But it won't count as their asset, and they will not lose, or they will be able to keep all of the government benefits. That's what a special needs trust is all about. After the death of your child or grandchild, your trust will say where the money can go. Maybe to your other kids, other grandchildren, charity, whatever you're interested in. Okay? So if you have a child or grandchild with disabilities, you probably should incorporate some type of a special needs trust into your planning. And the last subtrust or trust situation I want you to know about is you do all this planning to protect your assets for your children, only for them to screw it all up. They inherit the money. Look, Honey, I just inherited $500,000 from mom and dad. Isn't this great? Let's go get a bigger house. So they take that inheritance and they commingle it into a new house, and then your child screws up and they end up getting divorced. Who's going to get half of your inheritance that you just gave them? You just lost half. 50% of marriages end in divorce. So if you give the money to your kids and they commingle it, you're going to lose half of what you worked so hard for. Or very happy marriage between your child and their spouse. Very happy marriage. Your child dies. Her will leaves everything to him. And he and his next wife and her kids enjoy your money and not your grandchildren. If you want to control your money, you can do it in a trust. It's called a bloodline trust. It's called a family protection trust. Sometimes they call it a beneficiary protection trust. It's a trust that's going to protect your money for a generation or more. So what happens, and I have this in my will for my kids aren't even married yet. Not sure they ever, if anyone wants them, but. They're in their 20s and they're stupid right now. But I understand from all of my clients that at some point they become good people again. Please tell me that's true. It's true, right? Eventually they get married, they settle down, they have kids of their own, and then I'm smart again. Because right now, not so smart. Right? Yeah. Well, I'm hopeful. I'm hopeful. But I have this in my will for my kids. It's one of the most popular things going on in estate planning today. I don't leave my money to my kids. I leave my money in a trust for each of my children. And at a certain age, they will become the trustee of their own trust. But their money stays in the trust. Each trust, though, gets a co-trustee, which could be a brother or sister of theirs, or someone else, their best friend. They're not allowed to take money out of the trust without the consent of the co-trustee, but they can fire the co-trustee at any time and put someone else in. In English. They will end up with a trust where they control the co-trustee, can change the co-trustee whenever they want, which means they control the trust, because they can always put in a co-trustee that's friendly to them. Now, the money's sitting in the trust. If they want money, they just go to the co-trustee and sign here, and they take money out of the trust. They can do anything they want. Or they could buy their second home in the trust. Keep it there. Because if they get divorced, sorry, honey, I don't own anything. It's owned by a trust. Can't be split in a divorce. And when your child dies, the trust will say the money goes to your grandchildren, not to your daughter-in-law and son-in-law.
Somebody was getting a call.
I'm going to let it go. We're late. We're late in the day. We're late in the day. All right. All right.
Sorry.
I got my eye on you now. All right. So there's all these different trusts for all situations, and you may need none of them. You may not like any of them. They may be completely inappropriate for you. But there's a menu of trusts out there that may fit your situation. And you're all different. And you're all special in your own way. All right. That was my mother. Oh, yeah. Those of you who knew my mother, you're staring at her face right now. All right. Father's voice, though. All right. So that is the end of the formal presentation. A little bit of housekeeping here, and then we're going to have lunch, and I'll come around and ask questions. First thing I want you to know is I didn't come here today just to entertain you. I came to educate you. I'm also here to ask for your business, but that's about as far as I'm going to go in doing so. I want to be your lawyer. I want to be your lawyer. I want to be your lawyer. I'm asking for your business. Okay. I hope that you've heard a little bit today that maybe gave you some sense that I am comfortable in what I know, and I am very proud of the sterling reputation that my firm has in this community for 109 years. So I ask for your business. Also, there is, well, people ask, if I make a consultation with you, how much do you charge? I might as well get that out of the way. I charge $475 for the initial consultation. And by the way, I'm worth it.
Yeah.
If you go forward with work, though, I apply it to the work as long as the work is more than $1,000. If you're doing trusts and wills, it's going to be more than $1,000, which means the consultation will end up being free anyway. Okay? Also, 2 of you lucky people in here are sitting on my new book.
Oh, really?
So check under the pad, and perhaps you are sitting on my new book that is now on Amazon that basically tells you everything I just talked about. Anybody got a book yet? There are 2 of them out there. I would also check the empty chairs next to you. Ah, we got 1 book right here.
Yay!
Very good. And we got another book here for all of you other lucky people. You can either go on Amazon and buy it there, or when you come in for your consultation with me, I give you a free book anyway.
Well, there you go.
Okay? All right. By the way, that $475 consultation, if you don't give me 48 hours business notice that you're canceling, I'm charging you the $475 anyway. All right? Treat me with respect, I'll treat you with respect.
Exactly.
Fair enough?
Fair enough.
All right.
What if we get COVID?
One other thing.
I'm only
All right.
kidding. Just kidding.
Plenty of clients have canceled because of COVID.
We'll give you
Plenty of clients have canceled in the winter because it's too cold, it's snowy, it's icy. It's, you know what? I'm not feeling well today. Well, you know what? None of my clients are feeling well today. But if you have an excuse and you reschedule right there, respect goes 2 ways. I don't have a problem with that. It's those who don't show up, or they call at the last second, say, I'm not going to come, I don't feel, whatever. That's not fair to me, because I can book that time. All right. I don't know, this is the first time I'm ever doing one of these seminars.
Really?
No.
Oh, I was going to say, you're so damn good.
Well, thank you. No, I've been doing these seminars for 35 years. And if you can't tell, I love doing these seminars. And in my mother's influence, I love to teach. And I hope you really learned a lot today. If anyone has another group where you're looking for a speaker, I'm very happy to come. I don't charge for it. I love to do it. So if you have if you have a place where you think it would be comfortable for me to speak, I'm happy to come. In your packets is an evaluation form. No one is allowed out of here alive without filling out the evaluation forms. I want to know if you think I did a good job, if I covered the things you thought I would cover. Is there something you think I should have covered? Put it in there. If you know of another group that's looking for a speaker, put it down here and we will contact them. Other than that, it was a pleasure talking to you. It's good being back in my hometown. And thank you very much, everybody.
Thank you.
Thank you.